Remember how a few days ago Lively filed a request to file supplemental briefing in support of her Rule 11 motion? Well, we have a response from Brian Freedman. The first thing he points out is that this is procedurally improper for them to request supplemental briefing on something that happened way after they filed the motion. And that's because Rule 11 has something called a safe harbor provision, and that's to protect people's due process and constitutional rights. And how it works is that if you intend to file a Rule 11 motion against someone, you have to draft them a letter 21 days before you file the motion to allow the other side to fix the thing that you think that the Rule 11 motion is worthy of filing against. So, for example, if there was an improper pleading or something, and you tell them in a letter, this is what you're doing wrong, here is 21 days for you to fix it, and if you don't fix it, then we're going to move for sanctions under Rule 11. And he's saying, by virtue of the fact that they are addressing things that happened after May, depositions that happen in September and October, and they're outlining basically further bases for Rule 11 sanctions, that Lively didn't follow the procedural requirements of Rule 11. And I think that's a good argument. The next thing he argues is that the deposition transcripts of Steve Sarowitz and Jen Abel that seem to form the basis for this request for additional briefing or additional basis for Rule 11 sanctions occurred in September and October. Why are they waiting now that the motion for summary judgment has been filed to bring this up? Why didn't they do it then if they had that information in September and October? It seems to be another attempt to control the news cycle. And then lastly, he addresses the fact that Steve Sarowitz and Abel were unable to answer questions at their deposition concerning the allegations in the complaint without relying on insight from their attorneys. But a party is not expected to answer questions at his or her deposition about the factual basis of their legal claim. They're not lawyers, so they're not expected to answer legal questions. And he points to case law that says that a party's inability to articulate the factual basis for their claims at a deposition is not sufficient to warrant even summary judgment. And he threw back Lively's own argument in a previous motion to strike that involved her own inability to articulate the basis of her claims. And in a significantly redacted argument, Freedman says that both Sarowitz and Abel were able to demonstrate that there was ample evidence to support the defamation claims against Ryan Reynolds. And they reference a document produced by Lively herself that reflects something that Reynolds did that would support their claim for defamation. So we learn that Reynolds produced documents in this action pursuant to subpoena that seemed to support Wayfarer's position that defamation occurred by him. At least that's what they're arguing. And that Reynolds said something that can be reflected either in a deposition in a document that would demonstrate defamation. So they have Reynolds' own words in evidence produced in this action that supports the claims for defamation. So it doesn't really matter that at the deposition, Sarowitz and Abel were not able to answer those specific questions. So the Wayfarer parties say, we move to strike this letter request because there's no basis in Rule 11 for them to even ask for this. But if you're willing to give them this time, then they ask for 2 weeks to respond. I feel like this is an easy one for the judge. I mean, the request is for supplemental briefing. He could just say no. And honestly, he should just say no. This was a motion filed back in May that he does not want to touch anytime soon. And it's really, really easy for him to say, nope, I'm not giving you a supplemental briefing. Briefing is done. What I don't understand is that Lively's team keeps filing these things, putting redacted portions of things in letters, inviting the Wayfarer parties to do the same, knowing that all of that stuff is going to come out. So I just don't really understand what the logic here is. Like, what is the strategy here? How is this helpful? I mean, you guys tell me, is it really persuading the public when letters like this come out that's sort of allow people to draw the conclusion that the Wayfarer parties or individuals are bad or evil or did something wrong? Like, is that effective? Is the public buying that? Because it seems like every time they do something like this, it invites significant pushback and significant exposure, for lack of a better word, because of the evidence and unredactions and unsealings and everything that happens as a result. So I'm just scratching my head about this. I don't know what the strategy here is. I don't get it. The only thing I can think of is that there's a lot being filed in this case right now. Sanctions motions, motions to compel, MJOP, MSJ, oppositions, expert discovery. There's a lot going on. And I wonder if this is just part of the, like, gotta kick up all the dust, gotta make the other side work. That is something that lawyers do. It's totally evil, but it's something they do. So that might be it, really.